Okay, well, why don't we get started? We've got a solid amount of people here. Thank you so much for taking this time, most likely on your lunch break, to come work with us on this debt collection webinar that's been specifically catered for older adults, all about consumer debt, debt collection, and of course, navigating small claims court. So I'll just take us through a little bit of a beginning here with an agenda, some welcomes, just some things you need to note. And then, of course, we will dive on into the great presentation that Attorney Sarah has created for us that I'm super excited about. So just as a reminder, my name is Jessica Keegan. I'm from the Office of Economic Empowerment, and I use she, her pronouns. I'll go ahead and introduce a little bit more about the Office of Economic Empowerment. So we're a department with the Office of the Treasurer and Receiver General of Massachusetts. We deliver program to all residents of Massachusetts at every stage of their lives, regardless of their economic background. We also offer initiatives tailored to meet the unique financial experience of veterans, women, high school students, and of course, older adults. I'm going to just give you a moment to look at this 1 minute long explainer all about the Office of Economic Empowerment. And Sarah, if you give me a thumbs up if you can hear it, that would be fantastic.
Your financial well-being is our priority. The State Treasurer's Office of Economic Empowerment is here with free financial education to make your tomorrow even brighter. If you live in Massachusetts, you can access no-cost resources and online training, all designed with you in mind. Take it at your own pace or build community and learn with others. We offer help with budgeting, building credit, education and vocational training savings, financial wellness for families and communities, maximizing your money, planning for retirement, and more. Whoever you are, wherever you are in your financial journey, and whatever your money goals may be, we have the tools you need to succeed. Get started on your path toward a healthier financial future. Visit mass.gov/treasury/empowerment to learn more.
Great. I'm so excited about that 1 minute video. It just gives you a little deep dive of who the Office of Economic Empowerment is and what we can do to help you and the people around you. Okay, there we go. Perfect. So you may have noticed that this is not your standard Zoom meeting. This is a Zoom webinar. It will be recorded and it's being live streamed on Facebook as well. We'll make sure that you all get a recording of this so you can definitely circle back into anything that we talked about. So it will be uploaded onto a public website, onto our YouTube for other people to look at. So any information shared through the question function will be anonymous. So that also applies for things like the polls. Nobody's going to see your answers when you answer any of our polls. Just know that we are a public organization, so the chat record is subject to public record laws, and as such is not anonymous in that function. Okay, perfect. I will let Sarah go ahead, Attorney Sarah go ahead. But if you would like to check out any of our upcoming events, you can visit our website to explore more of the financial topics you just saw in that video, especially a lot of great topics specifically for older adults. You can visit myfinanciallifema.org. And if for any questions, you can definitely reach out to us at empowerment@tre.state.ma.us. And I know that's a few links, so we'll put those in the chat for you. I'll stop sharing so Attorney Sarah can go ahead and take it away.
Great. Thank you, Jessica. I am so excited to be here with you all today and truly honored to be presenting this webinar about what older adults should know about debt collection. So my name is Sarah Perlman, and I'm an attorney on the Consumer Rights Unit at Greater Boston Legal Services. And I have my contact info up here on the screen for everyone in case there's questions later. Feel free to reach out. And so I just want to say, whether you care for older adults, you're an older adult yourself, or maybe you just aspire to be one day, I hope this presentation will be interesting, informative, and helpful. So let's dive in. This is today's agenda. I just wanted to give everyone a sense of what topics I'll be covering. I won't bore you all and read you this list right out loud, but basically we'll be covering an overview of consumer debt in the US and how it affects older adults, and then walking you through the steps to take if you are one of the millions of Americans or older adults that's contacted by a debt collector this year. Then I'll cap it off by sharing some relevant resources, and hopefully we'll have time for some great Q&A. So let's just jump right in. The very first thing to understand about consumer debt in the US is that it is big business, big with a capital B, business with a capital B. At the end of 2022, the collective total of non-mortgage debt in the US, so that's all debt that's not mortgage related, think credit cards, student loans, medical bills, that reached $16.9 trillion. And that is a new record that is still growing to this day. And you may know that the younger generations do carry a majority of this debt. However, older Americans are shouldering a good deal of this burden. And I've just shared some numbers up here on the screen with you all to give some context to that. We're not talking about chump change. These are significant numbers that really do impact people's lives. And again, this is non-mortgage debt that we're looking at specifically. And what this growing debt translates to is that 1 in 4 people in the US currently has a debt in collection. So 26% of Americans currently has a debt in collection at any given moment. And the debt collection industry is able to generate $11 billion of revenue off of this collection activity every year. One reason it's so profitable is because in debt collection cases, in lawsuits, the debt collector wins 95% of the time. It's an overwhelming amount of the time the debt collector is winning. And it's even more staggering when you consider that they actually only have the evidence to prove their case and support their claim roughly around 10% of the time. So what explains this difference? There's a bunch of ways to answer that question, but one really key fact here is that defendants, consumers in these cases only have attorneys about 2% of the time. And you can imagine these big corporations, they almost always have a lawyer. So we're trying to change that. I'm going to talk about both some free legal resources and representation that's available to you. And also my goal for today is that you'll have the tools you'll need to even this playing field a little bit and advocate for yourself if necessary. So looking at consumer debt and older adults a bit more specifically, you may be surprised to learn, maybe not, that Massachusetts actually has one of the highest rates of economically insecure older adults in the country. It's a great place to live for so many reasons, but it's a very expensive place to live. And more adults are, over the age of 60 are struggling financially than in other parts of the country. It's also the case that 1 in 5 older adults are contacted by a collector about a debt each year. So 1 in 4 Americans is the national average, but when you look at this population, we're looking at 1 in 5, so still quite significant. And this is in fact a growing issue. So in 1989, 27% of older households had credit card debt, and that number has now jumped up to 41%. So you might be wondering, why do I start with this? Why am I sharing this information? And it's not to bum you out or overwhelm you, although those are appropriate responses in some ways to this information. I really share this to emphasize that if you or someone you care for is struggling in this way, you are not alone. You are not alone. This is a nationwide issue, and it's quite honestly appropriate to feel a bit overwhelmed. But the rest of this presentation is going to focus on practical steps you can take if you or someone you care for is one of those 1 in 5 older adults contacted by a collector this year. So we're going to start at the very beginning. What happens when you don't pay a debt? And this answer really depends on what type of debt we're talking about. And there are 2 types here that are relevant. I'm not going to spend a ton of time on this. This is just so you have context moving forward. So those are secured debts and unsecured debts. So starting with secured debts, that is a debt where something you own can be taken away if you don't pay. The classic example would be a mortgage on a house, but we also have auto loans. If you bought your iPhone or your cell phone on an installment plan, your television, your dishwasher, what have you. And if you stop paying whatever you owe for that particular item, the company you borrowed money from can usually repossess that property, often without going to court. That's not the case with mortgages and houses. There's a legal process that's required there. But going to the car loan, for example, if you fall behind on your car loan payments, it's possible that your car can be repossessed and without a court or hearing date before that happens. And unfortunately, you may still even owe money after the thing you purchased is taken back and sold. So continuing with the car example, let's say you still owed $10,000 on the car loan, it's repossessed and they sell it for $7,000, you would still owe, in many cases, that $3,000. And these repossessions and the unpaid secured debts can show up on your credit report and hurt your credit score. So we talked about secured debts. The other type of debt is an unsecured debt, and this is a debt where it's just a promise to pay. So credit cards are the biggest, most common example, but also student loans, your utility bills, medical bills. These are all examples of unsecured debt. And these also can show up when unpaid on your credit report. I just want to take a quick moment to share that you can check your credit report for free once a year at annualcreditreport.com, totally free of charge once a year to use that service. If you're sitting here going, oh dear, I don't know if these are listed on my credit report. After the webinar, you can go ahead and check that out. So if you don't pay an unsecured debt, what can happen? That's when you may start to receive letters and calls from debt collectors. The creditor or the collector may even sue you in small claims or civil court. Often that's determined about how much money is owed. Generally speaking, under $7,000, you'll be in small claims court. And I'm going to bring this up again, but I just want to mention that the statute of limitations, which is basically the legal deadline for these cases, is 6 years. So the creditor only has 6 years to sue you. And after that, they've missed their chance. They can ask you to pay, but they can't bring you to court about it. And I also want to just point out that you may receive something called a charge-off statement or get indication that your account has been charged off. And many people make the mistake of thinking this means, oh, I don't owe this debt anymore, which is understandable based on the term charged off. But unfortunately, that's not what that means. You are still liable for the debt. It's just that the creditor basically uses it as an accounting tool to keep track of the accounts that they're still actively collecting on versus the ones that they've charged off. So don't make the mistake of thinking that a charged off account has been wiped clean.
Sarah, can I ask you a question related to this?
Of course.
So I'm not sure if this is related to charged off as it could be sold off. Somebody asked as they had some debts that are, they had some debts that are sold continually. How does that figure if it's over 6 years?
So it's the 6 years starts of when your account basically get that charge off date, that first charge off date, that's when the time starts ticking. So it's not 6 years every time it's sold, it's 6 years total time to bring that lawsuit. And again, it doesn't mean they can't ask you to pay. It's just that they're not supposed to have a lawsuit against you specifically to pay. And if you have any more specific questions about that, your specific case, like I said, you can feel free to reach out to me. My email will be available again at the end of the presentation.
Thank you, Attorney Sarah.
Yes, of course. No, and thank you. I'm glad that people are asking questions. Please, I encourage you all to use the Q&A function. So I mentioned one of the things that may happen when you stop paying a debt is that you receive letters and phone calls from the debt collector. So this is first section here is going to focus on how to respond when you've been contacted by a debt collector. And the very, very first step is to confirm that the debt is valid. That means it's your debt, you owe it, the amount is correct, and you're paying the right person. And in fact, many debts, as the person who just asked a question brought up, are sold to these other companies that exist specifically just to buy debts and try to collect them. Some of the big names are Midland, LVNV, Portfolio Recovery Associates. If you've seen these names out there, these are debt buyers. So it's very common not to recognize the name of the company that's collecting a debt from you. And I just want to clarify, because somebody actually wrote in about this when they registered. If the debt is sold to a new company, you do still owe that money as long as they can prove their case that they properly purchased your debt and have calculated the right amount, but it doesn't wipe your liability. And the way you can check if your debt is valid is you can send what's called a debt validation letter. And if you send these letters within the first 30 days of hearing from a debt collector, they are actually legally required to respond to you with the information I have up here on the screen. And the purpose of this is that you get enough information to determine, is this accurate or not? And we actually have a free template available to you on the GBLS website. So you can just put in your information and it'll spit out a letter that you can plop in the mail and send to the collector, because it is important to note these requests have to be in writing to be effective. And somebody had actually asked, what happens if you submit these letters and you haven't received a response? If you did make your request within that first 30 days, then the creditor, if they don't respond, they're violating federal law. It's called the Fair Debt Collection Practices Act. And you can file complaints against the collector with a variety of organizations that do oversight for these companies. So one would be the Federal Trade Commission. There's the CFPB, that stands for Consumer Financial Protection Bureau, and then also the State Attorney General's Office, which I have specific information on how to file a complaint coming towards the end of this presentation. But if you don't receive a response and you've made that request within the first 30 days, you can file a complaint because they are required to do so. And let's say you're like, oh, well, I missed the 30-day window, but I'd still like this information. It's still worth a shot sending the debt validation letter. While they're not legally required to respond after that 30-day window closes, they often do. So it's worth it, but it's even better if you can get it within those first 30 days. And we also, I'm sure this is familiar for many people listening. We had someone also write in when they registered about feeling harassed by debt collectors. So I wanted to take some time to talk about what you can do to place limits on how often you're contacted by collectors. And in Massachusetts, debt collectors are limited to 2 communications a week per debt. So each debt you have, you can only be communicated with 2 times a week under this law. And I'm using the word communications because that has a very specific meaning under the law. And I just want to go through those here with you now. So a text message counts as a communication, an in-person visit at home, at work, wherever you are, that's a communication, and phone calls are communications, even if you don't pick up and even if the collector doesn't leave a voicemail. So if your phone rings and it's a collector on the other end, it doesn't matter if you don't pick up, not a word has to be spoken, that counts as a communication, and it's 2 total communications a week per debt. And for phone calls, there's also rules around when they can call you. It should not be before 8 a.m. or after 9 p.m. So just something to keep in mind. And there's one notable exception here, which is letters. Letters do not count as communications under this 2 per week per debt limit. But some more good news here, there is a way for you to request to stop receiving most letters and calls from debt collectors. So I say request because you do have to ask for this to stop. It's not something that can happen automatically. But if you send what's called a do not call letter, pretty aptly named, the collectors must stop contacting you to ask for payments on a regular basis. Just like those validation letters, these have to be in writing to be effective. So we do have a template available for you on our website that you can check out. And I want to be clear that there are still some circumstances where collectors might be able to contact you. For example, maybe they've sold your debt, or if they're going to be suing you in small claims court. It's not that you'll never hear from them again, but they do have to stop making those regular requests for payment. And you can also ask that they never contact you at your place of employment if you so desire.
Attorney Sarah, before you move on, I have a question about letters.
Yes, please.
So this relates to the past few slides. Somebody in the chat made a great point, as a lot of people who rent move frequently, or some folks might be evicted. What if the letter from the debt collector gets mailed to the address, but the person isn't aware? And how does that 30-day rule apply there?
Yeah, so you're saying if your initial contact happened, but you didn't learn about it until after the 30 days. I would say explain that situation in the letter when you send it out. And like I said, often even with those late requests, you will get a response. I know that's a really common problem for people who have, even if you've just moved once, I mean, mail can go to the wrong place very easily. So just if you explain the situation and send the letter anyway, there's a good chance that you'll still be able to get the response. Okay. Now we are moving on to a new section here, but first we have a question for you all, and you'll notice that one of the options for this poll that's coming up is going to be I don't know. And I want to encourage you, if that's the case, to be honest. It's okay. Like Jessica said, no one's going to see your individual poll responses here. And I'm sorry, Jessica, I actually don't see the poll myself. So
I'll launch it right now.
great. I was making
So
sure.
folks should be able to see this. Again, nobody's going to see what you answer, but we'll just display percentages afterwards. And Sarah, I'll let you know when a good amount of folks have answered it.
Great. Yeah, thank you. Thank you all for being a good sport here and participating, because I'm curious to know, are you collection proof? The suspense, gotta love it.
Everybody's still trickling in, so let's just give it. Okay, a lot of people have stopped answering now, so I will end the poll and show the results.
Okay, so we have, this is very interesting. It looks like a little over half of you have a good sense of what this means and you know where you land on the collection proof or not. And then I really appreciate the 46% of you who said, I don't know. And I'm happy to say we are about to find out together. So I'm going to spend this next section here talking about what income is protected from creditors. So the law protects certain income and property from being collected by creditors, even if you owe the debt. And these protections are called exemptions. So in Massachusetts, all public benefits are protected from collectors. So that's Social Security, if you receive disability, veterans benefits, anything along those lines, that money cannot be touched by collectors, even if it's shown in court that you owe the money. Similarly, if you are working and you make wages, you're of $750 a week or less, so that's gross before all the, not your take-home pay, but your gross pay, under $750 a week is completely protected. And there are additional protections. If you make over that, they can't take every cent over that $750 a week limit, but anything under it is completely protected. And then there are more rules that dictate how much exactly could be collected there. If you have a savings account, up to $2,500 can be protected. If you have a car and it's worth $7,500, or if you're over 60, actually $15,000, that's completely protected from collection. Unemployment benefits and other benefits as well. So I actually linked here to the full list of exemptions, and you can check that out to determine if your money is protected from collectors. So what happens if all of your money is protected from collectors? Then you are collection proof, which should now sound a little familiar. This is also sometimes referred to as judgment proof, but we're going to use the phrase collection proof because it actually is the case that you can still have a judgment against you. It's just that even if you are found to owe the debt, your money can't be collected. And so in that case, this is true for many older adults, by the way, because as I just said, public benefits, most pensions are protected from collection. If you're living on a fixed income, there's a good chance that you are collection proof. So if that's the case, you can ask the debt collector to stop contacting you because you're collection proof. And Mass Legal Help, an excellent resource that I will mention a few times throughout this presentation, has a free letter template that you can use and just plop in your information and send that on out. And then if you are collection proof and you are sued in small claims court, you can actually ask the plaintiff, the debt collector or the creditor, for what's called a hardship dismissal before your hearing. So you would contact the law firm listed on the small claim summons, which is the piece of paper you get from court telling you when your hearing is, who's suing you. If you contact the plaintiff's attorney and let them know I'm collection proof, I'd like to request a hardship dismissal, they'll ask for your income information. So if you receive Social Security, for example, they'll want your benefit verification letter. They'll want some documentation that your income is in fact protected. And they have the choice of dismissing your case. So this is a voluntary process for them. They don't have to say yes, even if you prove that you're collection proof, because you may still get a judgment against you. It's just that, again, you wouldn't be able to have any of that money collected. And I'm going to cover what happens if they say no and you have to go to court in the next section. But if they accept your request, your case should be dismissed, taken off the list, and you won't have to go to court. So just a
Amazing.
thing to keep in mind. Yes, a very good thing to keep in mind, especially for older adults who are more likely to have protected income.
Thank you so much, Attorney Sarah. I have a question about what is collection proof when we're talking about loans. Would federal student loans count for something like this?
So student loans are kind of their own beast, especially federal student loans. Some federal student loans, basically if the government's giving you money, the government's often the only one that can collect that money back. So that would be a more case-by-case determination. If the loan is from the federal government, then in some cases, benefits can be what's called garnished. So part of your wages or your benefits would go to pay that off. So I suggest if you have student loans specifically to go ahead and reach out to us or your local legal aid office so we can take a closer look at the details there, because that's a great question. Student loans are one of the things that gets treated a little differently in this context.
Thank you so much. And then I have another question, which we might talk about more. So you happy to pause on that one. But once you are collection proof, does that mean that the debt can no longer be sold or that a court case can't be brought against you from another debt collector?
Great question. The answer is no. That does not mean the debt can't be sold, and it does not mean you can't be sued. You could still, the debt can still be treated basically as normal. It can be sold to new collectors. And those collectors can attempt to take you to court. What it means to be collection proof is even if they take you to court, even if they win their case, your payment would be $0 because all of your money is protected. So the reason why these hardship dismissals exist is because, again, this is for the plaintiffs is about making money. And if they know they're not getting a cent from you, they're not as inclined to pay attorneys to fight the case in court when it's clear that they're not going to win either way, essentially. But it's really, really important to know it does not mean you can't be sued. If you get something from the court, do not ignore it, because it is still possible to get a judgment against you, which can hurt your credit score. This is really about, is your money and your assets, your property protected from those collectors if you are found to owe the money. So I appreciate the person who asked that question because that is a key clarification.
We do have more questions about this topic, but I'm happy to hold them towards the Q&A if you want to continue with the presentation.
Yeah, why don't we address them more in Q&A, because I talk a little bit more about this as we go. So there's a chance I'll address your question. And if not, I'm happy to spend more time in Q&A on this for sure. But I think the next section here is really important. So I want to make sure that we have a chance to talk about what happens if you are sued and you have to go to court, what to do. And I know we have one more question for you all right now. Jessica, whenever you're ready, we can go ahead and put that up on the screen. But I wanted to get a sense of how many people have been in this position. So if you don't mind sharing, if you've ever been involved in a small claims lawsuit, again, no one's going to see your specific answer. And in this case, defendant would be you are the person who's being alleged to owe money. Plaintiff would be if you sued someone else because they owed you money, and then no, pretty self-explanatory there. Let's give everyone a few minutes to think it over. Great. So, yep, most people have not experienced this. That makes sense. Even if you've been contacted by a debt collector, often it's resolved before we get to that point. But it does look like there's a handful of people who have been in this boat. And I want to make sure if that ever happens to you, that you know what to do. So thank you all so much for, again, being a great sport there. And here's the thing. If you walk away with one piece of advice that you remember, I hope it's this. If you are served a small claim summons, please show up in court. Please attend your court date. Show up to your court date, even if you're unable to make payments. Again, if you're collection proof and but your case was not dismissed, you still need to show up and be there in court, or you risk losing the case. And you can bring documentation of your income, or if you're experiencing financial hardship, you can bring that with you to court and use that to explain your situation. You should show up even if you believe you don't owe the debt. For example, if you think you've been the victim of identity theft or you've already paid this off, if you bring any proof of that to court, this is your chance to make your case in front of the clerk or the judge In small claims court, clerks serve the role as judges, so you'll hear me say that. And then, in fact, you should show up even if you owe the debt and you want to say in how much you pay. Perhaps you have the opportunity to settle, come up with a payment plan. But no matter what, please just show up to your court date, because if not, the court will generally issue a default judgment. And this means you automatically lose the case and may have to make payments. So the collector will automatically win, even if it's not your debt, if you don't show up. And we did have someone who had asked when registering, what happens if I miss the court date because the summons was sent to the wrong address? And if you miss your case because you never received the letter, if it was sent to the wrong place, the letter from the court telling you, hey, you need to show up, you can file what's called a motion to remove the default judgment. And you don't even need an attorney to do this. There's a general form you can fill out. Option 2, you check the box that says remove default. And on page 2, you just write up a quick, even 1 paragraph explanation of, I did not live here. This is when it was sent. I never received it. And a judge will take that in consideration and may allow a second court date. You might be able to get another chance to defend yourself in court. So if you did have a default judgment against you, these are typically most effective, these motions, if it's like within a year of your hearing. But if you explain the situation to the court by filing this motion, that's what to do in that situation. So I appreciate the person who brought that up when they registered. And I want to briefly go over some of the common defenses that we see people use in small claims court. So one being pretty straightforward, you already paid this money, you've paid this debt. In that case, you're going to hear me say this quite a bit, bring documentation to court, bring receipts of your payments and show them, hey, I've already paid this. Maybe you think you never borrowed this money if you don't recognize the credit card, for example. If you think that you've been the victim of identity theft, there are reports to file. For the FTC has a way to report it directly. That's the Federal Trade Commission. You might want to file a police report and bring that information with you to court to show the court, hey, I don't recognize this and I'm disputing it. Perhaps you think the amount they say you owe is wrong. It's not calculated correctly. It's not reflecting payments you made. Again, bring the documentation. Perhaps you declared bankruptcy previously, so the debt should have been wiped clean. We do see this, like, again, you just bring the documentation, show this is when I filed for bankruptcy, this is when this debt was taken out, therefore I no longer owe it. If the debt is older than 6 years old when the case is filed, that's again, that statute of limitations deadline that we talked about. And then this last point here, the debt collector did not provide enough proof you owe the debt. This is something that I'm going to go into a bit more on the next slide because it's a little more complicated, but also very important. So something you may not know is that even if you owe a debt, debt collectors must prove their case in court. It is their responsibility to bring enough evidence to court to convince the clerk or the judge that they can rightfully collect money from you, even if you think you owe the debt. This is their burden. That's the legal term we use. They have the burden of proof. So they have to prove it to a reasonable degree of certainty. They have to basically make their case to the court and say, hey, here's the paperwork, the documentation that shows we can collect this debt. It's the right amount, and this is the person who owes it. So I don't know if you need me to go through and read all these to you because I have them right here on the slide, but just to give you an idea of what are we looking for when we say proof. A contract would be a great start. That contract should dictate the interest and fees you're being charged, and there should be some evidence that you saw this contract. Either you signed it, maybe it was mailed to your address, but there should be proof that you agreed to a contract that covered the terms, fees, conditions of the card. If it's not the company you originally borrowed money from, they have to show all their receipts essentially of who they purchased your debt from, when was it signed over. These are called bills of sale. So they have to have this chain that shows we properly purchased this debt from XYZ company. And they have to also provide enough records to show that the amount they're collecting from you is correct. So credit card statements, for example, they have to provide enough credit card statements to determine, okay, this is the proper amount. And again, if there's interest in fees, there should be a card holder agreement or a contract of some kind showing you agreed to pay. So these are just some of the questions you could ask to determine if a debt collector has met their burden when you go to court. And now we'll cover what happens if you lose your case. So there's two answers here based on if you're collection proof or not, because if you're collection proof, you'll need to show the court that all of your income and property is exempt. Again, that means protected from collection. So if you receive a protected benefit, such as Social Security, you'll bring your benefit verification letter into court. This might also be referred to as a proof of income letter or a benefit letter. It's basically the letter from whatever organization that you receive the money from, stating you receive X amount per year, per month. If you work, but you make that under that $750 a week, you can bring in your pay stubs, but basically you just need to document and bring that documentation that shows that your money is protected from creditors. If you're not collection proof, there's still steps you can take. But what will happen is the court will issue a judgment against you and then schedule what's called a payment review hearing. And these hearings, the purpose is to determine your ability to pay the judgment amount. So based on your budget, your income, your expenses, what's your ability to pay the amount that you were found to have owed. And if you can show that you have money put aside for certain expenses, you can keep that money protected in addition to the amount that's already protected by law. So I mentioned that $750 a week is already protected. And then there are these other categories of protections. So for utilities, it's $500 a month, rent, $2,500 a month, and provisions, that means like supplies for your family, food, water, medicine, $600 a month. So here we're looking at $3,600 of additional income that can be protected if you can bring proof of these expenses to court with you. And as I mentioned, Mass Legal Help is an excellent resource, and they have a webpage that goes into this in a bit more detail. So if you're thinking this applies to you, I highly encourage you to check that out. And I mentioned that the goal of this presentation was twofold. One was to make sure that you felt empowered to advocate for yourself, but also I'm hoping that you have access to an attorney if you need one. And my organization, Greater Boston Legal Services, actually offers a free, we call it Lawyer for the Day program in small claims court, meaning we show up and we represent you for your case that day for free. And that is in Chelsea, Roxbury, East Boston, and Charlestown. And if that's the case, you can give us a call. We'll make sure you're on our list and we'll be there to help you. And then another wonderful organization that provides free legal assistance in the Boston area is Volunteer Lawyers Project. They cover Dorchester and BMC Central. And if you're sitting here listening in from somewhere outside of Greater Boston or in another court district that I didn't mention, there's another wonderful resource that I want to share, the Massachusetts Legal Resource Finder. This is a website where you can put in your zip code and it'll show you your local legal aid offices and any similar Lawyer for the Day programs near you. So now I'm just sharing a few more resources before we get to the wonderful questions that have been rolling in. I mentioned that I'm an attorney at Greater Boston Legal Services. We provide civil, meaning non-criminal legal assistance to Greater Boston residents that are low income or over the age of 60. And my unit that I work on is the Consumer Rights Unit, and we handle individual consumer rights cases and also do advocacy work to help protect consumers from unfair business and banking practices. And I have our intake number and email up here on the screen. So if you're in the Greater Boston area and experiencing a consumer issue, you can reach out and we'll see if we're able to help. And if you're not in Greater Boston, I listed a few of our other wonderful legal aid offices throughout the state below. And again, if you aren't seeing your region, I highly recommend checking out that Massachusetts Legal Resource Finder. And then finally, I wanted to share some other not necessarily legal aid, but still great resources that can help you if you're struggling with a legal issue, especially in the context of consumer law or debt. First, the amazing Office of Economic Empowerment who helped bring me to you all here today. They offer free financial education workshops and other resources like these webinars for older adults in Massachusetts. And I'm just very grateful for their support. And I couldn't recommend their services more. I also brought up the Attorney General's office has a specific consumer advocacy and response division. You may hear it referred to as CARD. And they can answer questions. If you have a dispute with a specific business, they are the organization that would address that. And they also can refer you out elsewhere. And I have both their phone number and a link to their complaint website right up here on the screen. Then there's actually Harvard offers some additional free consumer protection legal services in the greater Boston area, as well as Volunteer Lawyers Project and Justice Bridge that offers affordable legal representation if you're of modest means, so maybe not quite income eligible for free services, but you need affordable services. Justice Bridge is a great resource for that. And then Mass Legal Help, it's a free website that legal aid programs across the state all contribute to and put together. And they cover a variety of issues, and they have a whole subsection all on consumer rights. So if you have more questions or you're just looking to learn more, that's a great place to check out as well. Okay, so we have one more question for you, a question you'll be familiar with before I get to all of your questions here as well. But I just also wanted to say thank you. That concludes the bulk of my presentation. I have my contact info up on the screen. And after asking you all to answer a question one more time, I'm happy to get into your questions here. So, new question. This is especially dedicated to the 46% of you who bravely said, I don't know. Are you collection proof? And I'm curious to see how those numbers perhaps have shifted from the first time around.
Folks are still answering that. So if you already have answered that, I'll remind you that you can ask questions in the Q&A. You can in the chat as well, but it will be easier if you do post them in the Q&A, and I've recorded everybody's questions, so I'll make sure that we'll try to get to everybody that we have previously. So we have 71% of people answered, so I will share the results of this poll.
Look at that. Okay, so we went from 46% being unsure of what collection proof means to just 4%. And thank you to those two people for being honest. We can spend a little more time here explaining what collection proof means, but what I see from this is that you were able to take some information and understand how to apply it to your own life, which was really one of my goals here. So thank you all for participating in the polls. I think I'll just start by going over again what collection proof means, and then Jessica, you can let me know what other questions have come in. So just to maybe explain it a different way, when we're saying collection proof, what I'm talking about is, can the creditor force you to pay part of your income or give up some of your property to pay a debt that you have been found to owe them? And the answer is it depends, because certain types of income are protected from creditors, regardless of your liability or if you owe the money. You are entitled to protect enough money basically to make sure that your own basic needs are being met here. So if you receive public benefits exclusively, you make under $750 a week, in most cases, that means you are collection proof. If you are a renter, your car is worth either under $15,000 or $7,500, you are collection proof. And that means regardless of if a debt collector wins their case against you or not, your money and your property is protected. And that is really, again, the purpose of collection proof is, can the creditor take this money if you're found to owe it? And their law says certain types of money, the answer is no. And that link that I had shared earlier has the full list of exemptions for you to figure out, does this apply to me or not? So hopefully that clarifies any remaining questions. But Jessica, please let me know if there are more questions on being collection proof or anything else throughout the presentation. I'm happy to give it a shot.
Fantastic. And thank you so much, Sarah, Attorney Sarah. That was an amazing presentation. You can tell just how much people are paying attention, and this is important to them by the fact that we have so many questions. So I'll go ahead and give you some questions about being collection proof and what is protected when you are in small claims court. So would you be able to say if medical debt is something that's protected?
So this is a good question because I think it shows there's still maybe a little confusion on when we're saying protected. It's not the debt that is protected, it's your income and property that's protected. So it's true that medical debt has a lot of specific rules that apply when we're talking about medical debt. And an organization I didn't mention but is wonderful on this topic is Health Law Advocates. So Health Law Advocates, if you have a question around medical debt or insurance coverage, that's the organization I'd highly recommend. But it's not debts that are protected. It's your income, your money in the bank, your car. That's what's your benefits. That's what the protections apply to. I hope that makes sense.
Someone else clarified, can you be collection proof against medical debt?
I see. I'm honestly not 100% sure to just say yes or no. The answer is I believe that is the case. But again, I think it depends on if who you owe the money to, if it's a private hospital, a public hospital, private practice. So if you do have specific questions on medical debt, Health Law Advocates is the place to reach out to, and they're really skilled on these questions.
Okay, so I think we can continue talking about what is protected then and sort of get clarification more on that issue. So somebody asked a question in the Q&A, and then we also have a question in the chat relative to it. So I'll start with the question in the chat, in the Q&A, and then we can see how that applies to the question that was in the chat. So this person asked if you are still working for part-time for less than 750 a week, but you get a pension to cover daily living. Is that included in your protected income?
The answer is, and I'm sorry to keep giving lawyerly responses. Yes, but it depends. So most pensions are protected. There are some exceptions to that rule. And I would encourage you to check out the website I'd linked to that lists all the exemptions because that has more detailed information. But I can say that in our office, I don't believe we, in the last few years, have encountered any pension that was not protected. So the most pensions are protected, and if your wages are under $750 a week, that money is protected as well. The pension counts separately from those wages.
Amazing, and I think that does address the other question that had been in the chat about pensions as well. So I'll go ahead and go for another question that was in the Q&A. And I think this is in reference to when you were describing GBLS and your services, but I think this could also be good in general. What would you consider low income? Is there a specific level for that?
Yes, there is. And GBLS actually it's based on your household. So there's not one number I can just share right now, but GBLS has an eligibility calculator that you can check out on our website. And on top of that, if you're over the age of 60, the income limits don't apply. So if you're an older adult listening in, or your concern is for an older adult, if you're over the age of 60, you are eligible for our services. And low income, it does have a specific meaning. So thank you for asking that. You can look up the GBLS eligibility checker. If you just Google that, it will come right up. And you can put in your income, your household size, and it'll tell you.
Okay, thank you. So sorry, the lights turned off behind me. So we do have more questions unrelated, but I did want to ask, you mentioned that this can affect your credit report since debts are sold between companies very frequently. How long will this stay on your credit report?
Another great question. Something I didn't understand until I started doing this work is that each credit reporting bureaus, there's Experian, TransUnion, they all have their own rules and systems in place. That's how you can end up with different scores across the three. And so it really, again, I know how much of a lawyer I sound like when I say it depends, but that is the case, that it depends. And if you're worried about, if you think that there's a debt on your credit report that you either already paid or you were found in court to not owe it, you can file a dispute with each of the credit bureaus challenging the presence of that debt on your report. And otherwise, I don't know if there's a consistent length of time that they're supposed to stay on there. I think, again, it depends on the type of debt. Was it paid off but late? Was it still outstanding? There's all these other factors that come into how to answer that question. But the best answer I can give is you should take it up directly with whatever credit bureau you're seeing that debt on, because that's if you look up credit dispute, that's what you're looking to do there. You would be able to dispute it.
Thank you for taking all of these questions. I know that we have a few, so much appreciated. Go back to a topic we had just had questions about. Speaking of sort of income, does your 401k or your IRA count as separate for protection?
I believe that is the case. That is separate, because it's a little different than income. That would be probably considered an asset under these exemption laws. And again, I'm going to point people to the full list that you can check, so I don't give any misinformation by mistake. But my understanding is that there are protections in place for that kind of money.
Okay, and I know that Attorney Sarah has been mentioning a lot of links that she's mentioned. So just remember that you're going to get all of these slides and a recording of this, and we'll make sure to have all of the links in a separate document so you're able to access those resources easily, whether you want to share it with your community or just look back over it yourself. So I have a few questions that I think we can condense about the 6 years from the debt being incurred. So I'll say for the first part of this question, just to confirm, once 6 years has passed from the debt being incurred, you can't be sued by anyone about it. Is that correct?
Yes.
Okay, so even if you have debt from, say, 2007 and people are saying you need to pay for it.
If your debt's from 2007 and you're just being sued on that now, they are too late. They missed the boat. They can, I want to be clear, there's being sued for a debt, and then they're just being asked to pay or being harassed into paying. So they're allowed to keep asking you to pay, but they cannot bring a new lawsuit against you to make you pay after 6 years. One thing to clarify is if your debt was from 2007 and you already had your small claims case like back in 2007, 2008, and you were found to owe that money, those judgments last for 20 years. So that's how long the collector has to try to collect the money from you. And this really comes up actually in the context of being collection proof, because let's say you come into some money later on, you get a car worth over the $15,000 limit. For the next 20 years, if a judgment's been made against you, the creditor has the right to come back and say, hey, it looks like you have money or a property we can collect now. But if the debt is from 2007 and this is the first you're hearing of it in court, they have missed the boat by quite a bit there, and it's too late.
I think that really neatly addresses another question that had been relative about like how long do they maintain your case in case you later make money on something that's not protected. So that 20 years and that really does help that other question that we had on that front. I know that we've spoken about how it's a lot of different kinds of debt when we talk about medical debt, but is this relative to tax debt? As I know that can be a tricky subject with the government.
Tax debt also falls in a different category. So you may remember that, the title of this presentation is consumer debt, and maybe I should have been clear about what that means. So we're not looking at debt that's owed to the government here for the most part. This is consumer debt. So the main source of consumer debt that we see is credit card debt, or other like loans for, your car or something along those lines. Tax debt, I'm not a tax attorney. I'm not super well versed in that. It depends on if the tax debt's like tax debt for your house or just the IRS, like all these different factors would come in. But so yes, tax debt has it's treated its own category of debt.
That makes sense. Consumer debt only. And I think you've definitely brought up a lot of resources on that front. I wanted to just go back to that topic you were just mentioning. And I might ask the person who asked this just to clarify a bit, but they asked if a new debt collector after 6 years tries to collect, does that go on your credit? My clarifying question would be, Is that on the same debt from previous, or is this a new debt? So you can feel free to put that in the chat if you want to clarify, and I can go ahead and ask Attorney Sarah a different question about some of the resources that you had posted. Does legal aid also help with Medicare disputes? And you might not know this one, but we can definitely direct them to the website.
So the short answer of that would be yes. We have a different unit at GBLS. I mentioned I'm the consumer rights unit. There is a separate unit at GBLS, the Elder Health and Disability Unit, that covers Medicare questions. So if you call GBLS, and you don't have to know which type of problem you have. If you have a civil legal issue that you think we can help you with, if you call the GBLS line, they should direct you to the right department. So that wouldn't be my team necessarily working on that, but legal aid in general tackle Medicare disputes? The answer is in some cases, yes. So that would be a valid thing to reach out for help with.
Right, and I think this would be our last question, considering we are at 12:57 and questions have trickled. So we got some clarification on that. If a new debt collector after 6 years tries to collect, that was about the old debt coming back.
Oh, so okay, great. So I'm so sorry to do this again. It depends on the credit reporting agency and if that collector decided to report it. If that happens, I think you could look into doing one of those credit disputes, but the short answer is it depends on what actions the new collector decides to take. It's kind of up to them whether or not and what information they report to those credit reporting agencies.
Sometimes the best answer you can give is it depends. And honestly, that's 100% understandable, just with all the nuances that come with debt and legality. You've given us a ton of links to resources and guides of what is collection proof, what isn't, and things on that nature. So folks can reference all of that. But I think that's all of our questions. So I wanted to first say thank you so much for answering these questions, giving this presentation. If folks had more questions moving forward, I'll make a note of them and hopefully we can bring them over to GBLS to send out in our follow-up email. And that follow-up email will, of course, have the slides, the link to this recording, and the links that we need. So don't worry, I haven't forgotten about anybody. So I just want to give a big shout out to Attorney Sarah for making time to do this presentation, and for all of you folks for answering honestly when a lot of tough questions came up, and for feeling comfortable to ask questions. There will be an exit survey that pops up when you hit the exit button. If you let us know if you like this, we'll do more things like this. So we appreciate you filling that out.
Yes, thank you all so much for joining today. I really appreciate your questions and your participation, your attention. Thank you to Jessica and the rest of the OEE for helping make this possible. And have a great afternoon, everyone.
Thank you all so much. We'll be in touch. Have a fantastic day and happy holiday.